Welcome to the Supreme Court of the United Kingdom. Today we are hearing an appeal in the case of Matthew and others and Sedman and others. It concerns a question as to when a period of limitation begins under the Limitation Act 1980, when a cause of action came into being at or on the expiry of the midnight hour. In particular, does the day which commences at or immediately after midnight count towards the calculation of the period of limitation? Today, Mr. Jeremy Cousins QC is presenting the Appellants appeal, and Ms. Claire Dixon is presenting the case for the respondents. Before inviting Mr. Cousins to open his appeal, I will introduce the panel who are hearing this matter. I am Lord Hodge, and sitting with me today is Lady Arden.
Good morning.
Lord Sales.
Good morning.
Lord Burrows.
Good morning.
And Lord Stevens.
Good morning.
I now invite you, Mr. Cousins, to begin your submissions.
My Lord, I'm grateful for the introduction. May I add that Mr. Christopher McNall, who on my screen is immediately below me, appears with me for the appellants, and Miss Dixon for the respondents is also appearing with Mr. Nicholas Broomfield, but he's not actually visible on the screen. My Lord has already said a few introductory words about this case. If I may just add one or two very preliminary observations before I turn to the meat of our submission. For the purposes of reckoning periods of limitation, the Limitation Act 1980 consistently refers to the expiration of a period of years from the date on which a cause of action accrues. The broad point in this appeal is about identifying that date. Lord Justice Irwin in the Court of Appeal has described this as a midnight deadline case. So, is the relevant date from which time begins to run against the person who makes the claim that of the day before or the day after the relevant midnight? The appellants say, in this case, that the date is the day after the relevant midnight. And not surprisingly, the respondents contend that in a case of this kind, the date is the date before the relevant midnight. I turn then to the facts. The court has, of course, seen the statement of facts and issues which are agreed, and they are in a very narrow compass indeed. Would it assist if I were to say anything about the factual matters, or may I simply go straight on to the issues and the substance?
I think we are familiar with the factual matters. You can take it. Lady Arden is going to say something in just a second. You can take it that we have read the judgments in the courts below, the statement of facts and issues, and parties' cases. So we are familiar with the layout, for example, of the history of
Yes.
The limitation. Lady Arden, you're muted at the moment.
The judge set out some of the terms of the scheme of arrangement, but I don't believe I've seen the scheme. Is it possible to see a copy of the scheme and the court order?
Certainly it is. If I might just have a moment.
Well, come back to it if you wish.
If necessary, could I come back to it after the mid-morning adjournment? But it's certainly available. I don't think it's actually been included in any of the materials that we have. Mentioning materials, could I just check, and I apologize for not doing this a moment earlier. The court will, of course, have seen the hearing bundle, which is 690 odd pages. And I trust that each member of the court has received, in addition, the appellant's additional authorities and the supplemental additional materials. So the bundle altogether runs to about 730 odd pages.
We have received the additional materials. They have not been incorporated into the bundle, but we have them in separate form.
I'm grateful for that indication. I anticipate we won't be referring to those supplemental materials to a great extent, but I think there might be the occasional reference. The agreed issue in the case is, should Friday, the 3rd of June 2011, have been included or excluded for the purposes of limitation, and consequently is the welcome claim barred? I appreciate that the court has read the judgments both at first instance and in the Court of Appeal before, but could I just highlight one or two very important features of the judgments below? First, Judge Hodge QC, sitting as a judge of the High Court, reasoned at paragraph 27 of his judgment, which is at page 160 of the bundle, that the claim was barred because if issued on the 3rd of June 2017, it would have been issued more than 6 years after accrual of any cause of action. And then he said these extremely important words, because the action had arisen at the very first moment of Friday, the 3rd of June 2011. We agree with that with respect. The action had accrued. We maintain it's fundamental to our case at the very first moment of June the 3rd, 2011. That finding, I should just point out, was not challenged by the respondents. In the Court of Appeal, both members of the court, it was a two-judge court, Lords Justices Underhill and Irwin, upheld Judge Hodge's decision. We address the Court of Appeal's decision in paragraphs 33 to 39 of our written case, which is at pages 102 to 106 in the bundle, and obviously we'll come back to it later. But I'd just like to highlight a couple of points arising from the judgments in the Court of Appeal. First, Lord Justice Irwin, who delivered the first judgment, specifically accepted two principles fundamental to the appellant's case. Namely, one, the day of accrual of a cause of action is to be excluded. We see that at paragraph 17 of his judgment, that's page 144, a correction in our written case. I'm afraid we said it was paragraph 16, not paragraph 17 where he says that. The second point, which he accepted, was that English and Welsh law will disregard fractions of a day. There is a very great deal of authority to support that proposition. I will, if I may, just mention now the case of Pugh and the Duke of Leeds, an 18th century case, a decision of Lord Mansfield. That case is in the bundle. It's at page 173. Lord Justice Underhill accepted that in cases where a cause of action accrued partway through a day, it was established that the day of accrual is to be ignored for limitation purposes, and he too, at paragraph 39, page 150, appears to accept that fractions of a day are to be disregarded. Both members of the court, by slightly different routes, reached the conclusion that because this was a midnight deadline case, the established rule, that is to say, the rule of excluding the day of accrual, would not be applied. May I turn fairly briefly to the all-important words of the Limitation Act
Lord
1980
Sales, I
itself.
think, wishes to
Sorry,
ask a question.
Mr. Cousin, just before we move away from the Court of Appeal,
Yes,
did you want to say anything at this point about what Lord Justice Underhill says at paragraph 38, 4 lines from the end, that the cause of action arises at, not after midnight?
my lord, yes, I'm going to address that in rather more detail later, but I make this short answer to it, if I may. And it's very closely tied with the wording of the Act itself. The Limitation Act 1980, like its predecessors, requires a date of accrual to be identified so as to set the period of limitation running. It's absolutely crucial to set the date. We say that in those circumstances, the date of accrual must be identified, and there are only two candidates, the 2nd of June or the 3rd of June, but there isn't an in-between, because the law doesn't recognize fractions of a day, and the law doesn't recognize the fiction of a scintilla temporis, which has been rejected in case after case, certainly at House of Lords level, and in many first instance decisions as well. In short, we say that there is no escape from the operation of the provisions I'm about to come to by a holding that the cause of action accrues at midnight. I do apologize, there's a landline phone ringing. May I just, oh, it's been muted.
That's fine.
I thought I'd taken every precaution. My apologies.
Not at
May
all.
I turn then to the provisions of the Act?
Yes, thank you very
Now,
much.
there are three causes of action that we're concerned with here: tort, contract, breach of trust. Section 2 of the Limitation Act deals with tort, and you'll find it at page 166 in the bundle. An action founded on tort, it provides, shall not be brought after the expiration of 6 years from the date on which the cause of action accrued. We see that formula repeated in paragraph 5, page 167, in relation to contract. I didn't read the words fully again. And if we then go to section 21, subsection 3, which is a page 169, this deals with liability for breach of trust. And it provides as follows: subject to the preceding provisions of this section, an action by a beneficiary to recover trust property or in respect of any breach of trust, not being an action for which a period of limitation is prescribed by any other provision of this Act, shall not be brought after the expiration of 6 years from the date on which the right of action accrued. The only difference between the material provisions is that in relation to a breach of trust, it's a right of action rather than a cause of action, but the material provisions are the same. The same formula is in fact employed for the running of time and its reckoning throughout the many provisions of limitation contained in the 1980 Act. To mention one or two examples: Section 3, action in conversion; Section 4A, action for defamation; Section 8, action on specialty; Section 22, actions against the deceased estate. It's what each of the provisions focuses upon, and I should be focusing upon this morning, are those critically important words from, date, and accrual. And in developing our case this morning, I wish to advance what we say are a few key propositions which should be determinative of this appeal. And those propositions can be hung around those three words, but I'm going to take them in a slightly different order, if I may. The first proposition and the next few relate to date. And it's this.
Mr. Cousins, it's a very minor point, but just so I'm absolutely clear, I don't think anything is going to turn on this. Is the claim brought in contract as well as in tort and for breach of trust? I don't quite see where the contract claim's coming in. I think you mentioned Section 5.
Yes, my lord, I thought I'd taken the court to Section 5. It's on, the section itself is Section 5 at the foot of page 167.
Yeah.
The contract claim is a claim for failing to exercise the competence which a professional trustee should perform. So it's the features that give rise to the liability are all the same. It's the relevant cause of action arises from the same facts.
Yes, I think my only point was, it was pleaded, was it, as a claim in contract as well as in tort and for breach of trust?
It was indeed, my lord. They were pleaded as concurrent claims.
Thank you.
Could I then turn to our first proposition, which is that there is, as I understand the position, some non-contentious undergrowth that we can cut away. And the non-contentious undergrowth is whether it is possible for this case to be disposed of on the basis of there being a scintilla temporis between the two dates. Was there ever a moment in time which was neither the 2nd of June nor the 3rd of June 2011? We submit not. And I think that's completely non-controversial. We assert it in our written case at paragraph 38.1, page 104. And the respondent's written case emphasizes this very same point in paragraphs 15, 20 to 22, which you'll find if you want them at pages 116 and 118 to 19 of the bundle. I don't propose to dwell upon this at the moment, given the fact that I understand it to be non-contentious. I mentioned a moment ago House of Lords authority, which dispels any notion of there being room for such a legal fiction as scintilla temporis. It's to be found in Dodds and Walker, a case that the Court of Appeal relied upon in this case, in reaching its decision, and in the case of Cannes and Abbey National, a case that both parties cite in this court. No question arises on Lord Justice Irwin's analysis of any such legal fiction as scintilla or punctum temporis, because Lord Justice Irwin's analysis dealt with the issue by, as he put it at paragraph 16 of his judgment, by not attributing the cause of action to the later date in the case of what he called a midnight deadline. Lord Justice Underhill dealt with the point by saying that there was no part of the 3rd of June when the appellants did not enjoy the cause of action. But when he said that, he didn't address the implicit suggestion which arose from what he was saying, that the cause of action had arisen, as we say it must have done if there is no permissible or identifiable scintilla, as it must have done on the 2nd of June. So I move on from the undergrowth, which I hope we can chop away and forget. The next point in relation to date. The appellants had the entirety of the period up to and including the whole of the 2nd of June, which was called the bar date under the scheme, to make a claim under the scheme. Everyone concerned with arguing or deciding this case has accepted this premise. In the statement of facts at paragraph 9, the respondent's case at paragraph 4.2, Judge Hodges' judgment at paragraph 27, and Lord Irwin's judgment at paragraph 7. So I come to the third proposition, which is that it follows from this common premise that no cause of action against the respondents was sustainable or could have been commenced until the 3rd of June. If I could just elaborate on that for a moment. Suppose that the court office were never closed. It were possible to issue a writ or a claim form at any time of the day, right up until the moment when the 2nd of June was over. It would not have been properly permissible to issue a claim against the trustees for breach. How could it be? They had the entirety of the 2nd of June to present a claim under the scheme. It follows from that Judge Hodge was right when he said that the cause of action, or causes of action, accrued at the very first moment of the 3rd of June. But that means that the date of accrual, an important word, the date, was the 3rd and not the 2nd of June. And if that follows, then applying what we have called the long-standing rule, to which I'll come shortly, the action cannot be statute barred. Now, the respondents, by their written case, seek to escape from that conclusion which I have just identified, based upon an analysis at paragraph 23 of our case, that's page 120, that the expiry of the 2nd of June and the loss sustained by the appellants are simultaneous and indissolubly bound together. That's their words. We submit they are not simultaneous. We submit they could not be simultaneous. The events or states of affairs in question did not exist at the same time and could not do so, because only upon determination of the first period, that is to say, the period during which it was possible to advance a claim under the scheme, only upon the end of that point in time could a cause of action accrue. Only then, in this world in which the court office is open 24 hours a day, only then could a claim validly be issued. There is no question of simultaneity or indissoluble binding together. The two states of affairs are incapable of mutual coexistence. They are sequential states of affairs. The respondent's written case at paragraph 14 contends that the causes of action arose upon the expiry of the last moment of the 2nd of June 2011. But upon the expiry of that last moment, it was already the 3rd of June and not the 2nd. Can I move on from date to the important word from? Our submission in relation to the word from is that once the moment of accrual of a cause or right of action is correctly identified, the case falls to be determined in accordance with each of the relevant sections dealing respectively with tort, contract, and breach of trust, so that the appellant had 6 years from the 3rd of June to commence the claim. On the basis of long-standing authority, which goes back certainly to the late 18th century and includes the, for the purposes of this case, significant decision of the House of Lords in the Scottish appeal of Mercer and Ogilvy, which was later applied by Sir William Grant, Master of the Rolls in Leicester and Garland in 1808. The word "from" signifies a period subsequent to the date of the event itself, which for present purposes is the accrual of a cause of action. And that date of the relevant event is to be excluded from the reckoning of time for the making of the claim. Once that date, the 3rd of June, is excluded from the reckoning, then it is common ground that the claim would have been brought in time. I can deal with this very shortly, and it's convenient to now. It is now well established in English law that on a day, if a cause of action accrues on a day when the court office is closed, then the writ or claim form can validly be issued on the next day when the court office is open. So if, in this case, it was in fact a Saturday, the 3rd of June 2017, the first working day when the court office was open was the following Monday, the 5th of June, when the claim form was in fact issued. And everybody is agreed that is the law, and it was so determined finally in a way that is certainly binding at Court of Appeal level and below, in a case that I'll be coming to later, in the case of Pritam Kaur. May I then move on to the word accrual, or accrued as it is in the statute. What we submit matters is when accrual occurs. We see that in respect of each of the sections, tort, contract, and breach of trust, focuses on accrual, not the time of day when accrual occurs, but the date of accrual. And it doesn't matter for limitation purposes whether any of the causes of action with which the statute deals arises from an act, an omission, an event partway through a day, or any other combination of circumstances. What matters and what must be identified is the moment of accrual, howsoever such accrual occurs, of a cause of action. And that day, on the authorities, is to be excluded from the reckoning. The Limitation Act draws, as I've mentioned a moment ago, no distinction between the commencement of the running of the limitation period based upon the point during a day when a relevant event of accrual occurs. After midnight, just after midnight, a nanosecond after midnight, noon, a moment before midnight, doesn't matter. That is consistent with the approach that has been adopted in English law over centuries. And for that, we have the authority of Leicester and Garland, which case was an explicit following of the decision of the House of Lords in Mercer and Ogilvy in 1796. In both Mercer and Leicester and Garland, both those cases described a day as an indivisible unit in time. Lord Mansfield first, I think, used that phrase in Pugh and the Duke of Leeds about 20 years before Mercer was decided. So what matters is the date, not the time. The only case, apart from decisions of the courts below in this case, the only case which suggests anything to the contrary is the first instance decision of Mr. Justice Channel in 1913 in Gelmini and Morija, a case which I'll come to later. Gelmini has drawn support from the learned author of McGee on limitation periods, a text cited by our friends. So, before I move on to the next point, may I just develop this slightly further and say it is axiomatic that the date of accrual of a relevant cause of action must be ascertained before it is possible to calculate the period of 6 years from the date of accrual. The words of the statute demand that a date of accrual be identified for all causes of action with which the Act deals. Parliament has decided that it is the date that marks the starting point. There's no room for any gap or any scintilla. There's no room for distinctions of time of day. It is the date and only the date that matters. If the date of accrual is to be excluded in some cases, and it is, we submit, beyond argument that it is, then it must be excluded in all. It serves no purpose to suggest that in some instances of construing other documents, such as leases, will trusts, or patents, a differing construction of different words may give rise to different results. And there is certainly no suggestion on this side that it isn't possible, for example, for Parliament, if it chose to do so in another enactment, to draw a distinction and not to exclude the day of an event. It could direct that time is to run from the day of the event itself. A lease can do that. Commonly, that is exactly what happens in lease cases. It's what happens with patents as well. Some of the authorities that our friends rely upon are to that effect. But that isn't the Limitation Act, where there is a well-established body of authority at a very high level to that effect. Now, as for the decision of Gelmini, and I'll deal with it in detail shortly, we submit it was wrongly decided and was wrong in principle. It was inconsistent with a limitation point arising in a criminal case of Radcliffe and Bartholomew, a decision of the Divisional Court in 1892. It has been disapproved in two later 20th century cases, Maron and Dawson Bentley, and expressly disapproved in that case, a decision of Mr. Justice Havers, and implicitly disapproved in Pritamcourt and Russell, a 1973 decision of the Court of Appeal. So, before I turn to the authorities, just to recapitulate, it's our submission that the cause of action in this case accrued and only can have accrued on the 3rd of June 2011. And once that point is reached, the long-standing rule directs that the 3rd of June 2011 is excluded from the reckoning. May I then turn to the long-established rule, as we have called it. There are, in this field of identifying when time begins to run, quite a number of cases, and you've got perhaps more than you would wish before you in the bundle. And I'm not going to, I hope I'm not going to weary you by going unnecessarily through all of them. I couldn't attempt to do so in the time available.
No, I think it would be helpful if you focus on the major cases.
Yes.
We obviously have your written case, and we will take that fully into account in our deliberations.
Well, my lord, I'm very grateful. That is the course which commended itself to Mr. McNorland and me, and we've picked out what we think is a representative sample, but nevertheless of landmark decisions in this field. The leading cases that we propose to address in turn are Mercer and Ogilvy, the 1796 decision of the House of Lords, Leicester and Garland, 1808, Sir William Grant, the Goldsmiths Company, and the West Metropolitan Railway, 1903 Court of Appeal, which was endorsed by Lord Goddard, the Lord Chief Justice in Stewart and Chapman, which concerned a criminal limitation point. Lord Goddard said that the rule was firmly established by the time that the Goldsmith case was decided, if it hadn't been already. It's an approach to the reckoning of time which is reflected in both the CPR. We've put the materials in the bundle. I think I don't need to go to them, but it's in the CPR at 2.83b, page 512 in the bundle, and that is in turn consistent with the old rules of the Supreme Court, Order 3, Rule 2, which you will find in the additional authorities bundle at page 735. I've mentioned the case of Pugh and the Duke of Leeds, a decision of Lord Mansfield in the Court of King's Bench in 1777. We deal with it at paragraph 7 and 8 of our written case. That case was about a lease. If from the date of the indenture of the lease, which period for which the lease was, from which the lease was to run, was inclusively interpreted or exclusively interpreted, affected the validity of the lease. If exclusive, the lease was void because the power under the marriage settlement concerned only enabled a lease to be granted in possession, not in reversion. In his reserved decision, Lord Mansfield, having reviewed authority at very considerable length, explained why, at page 725 in the report, he reached the conclusion that an inclusive interpretation should be adopted. And it was from the context, we've set out the text of the relevant passage in our written case, but perhaps I can summarize. The reasoning in that case for the running of the lease, for the calculation of the running of the lease, was that the whole purpose of the grant of the lease was to create a valid instrument, a marriage settlement, and it cannot possibly have been the grantor's intention to create a lease which would be invalid at its inception, if that's not a contradiction in terms. It was in that case that Lord Mansfield made the observation that a day was an indivisible unit of time. You'll find that at page 173 in the report. In paragraph 9, we mention a case called Ex parte Fallon, which was decided in June of 1793, just months before Mercer and Ogilvy. That is a case of an exclusive interpretation as to when time begins to run. But may I now turn to the first of the landmark decisions that we rely upon. It's a Scottish case, but has been fundamentally influential in the approach to the running of time in English law ever since it was decided. Mercer was a decision of the Court of Session in December 1793. The case ultimately reached the House of Lords in March of 1796. The case arose under a provision in the 1696 Act of the Scottish Parliament for regulating deeds done on the deathbed. The court may appreciate that until the 1696 Act, the rule in Scots law was that if a person made a deed, having already contracted the illness which caused their death, then the deed could be held to be invalid, although there were various exceptions, of course, to that, if the person could be shown to have been in good mental health. But what the 1696 Act did was to regulate the law of the deathbed, as it's been referred to in some of the cases, so that if the deceased person survived for a period of 60 days from the date on which the deed was made, then, albeit in the language of the statute, which you'll find if you're interested to see it at page 702 in the bundle, albeit in the language of the statute, that the person concerned had not been to Kirk or Market in the meantime. By a majority in the Court of Session, it was held that the deed should be reduced, invalidated, because the Act required that the grantor should live for the space of 60 days, when even counting the day upon which Mr. Mercer had died, he'd lived for 58, certainly not more than 59 days. The dates being deed created on the 22nd of February, 1791, death on the 22nd of April, 1791. Well, on no reckoning could it be longer than 59 days. So the deed was invalidated. The House of Lords heard the appeal in 1796. There were just two speeches in the House of Lords. Lord Thurlow, with whom Lord Loughborough, as he then was, agreed, having heard argument over 4 days, dismissed an appeal from the Court of Session and ordered that the interlocutors therein complained of be affirmed. On the basis that, and we've set out the wording in our written case, the terminus a quo mentioned in the Act is descriptive of a period of time and synonymous with the date or day of the deed which is indivisible, and 60 days after is descriptive of another and subsequent period, which begins when the first period is completed. The day of making the deed must therefore be excluded, so the maker only lived 59 days of the period required. Had he seen the morning of the 60th or subsequent day, it would have been sufficient. The rule of law above mentioned, dies inceptus pro completo habetur, then applying and making it unnecessary and improper to reckon by hours or to inquire if the last day was completed. We would submit that the matter could not really be put more clearly than that, and the authority of that passage has been respected and applied ever since. I will just mention, you may have picked it up already, there are in the bundle 2 versions of Mercer and Ogilvy. There is no material difference between the reports. Counsel's submissions are recorded in slightly different terms in the reports, but the speech of Lord Thurlow is not materially different from one report to the other. Moving on, our submission was applying that approach to the interpretation of the 1980 Act. The terminus a quo was the 3rd of June, which is indivisible, and the subsequent period which began thereafter of 6 years cannot have ended before the court office would have closed on the 3rd of June 2017, had that day been a day when the office would have been open, which of course it wasn't. As their lordships recognised in Mercer, the result of excluding the day of the event in question is that the day of accrual of the cause of action is to be excluded. until the decision of His Honour Judge Hodge in this case, the approach described in 1793 and affirmed by the House of Lords in 1796 has, with only one exception, the decision of Mr. Justice Chanley in Gelmini, not been adopted and applied in limitation cases. May I move on to Leicester and Garland, the decision of Sir William Grant in 1808. Sir William Grant, incidentally, was junior counsel for the respondents in Mercer. Something which he mentioned in the course of his judgment. I'm turning to paragraphs 13 and 14 of our written case. Leicester and Garland wasn't a limitation case in itself. It arose on the interpretation of a condition in the will of Sir John Leicester, which made provision for the children of his sister, Sarah Poynter, but upon condition that she should provide security not to marry one A. It's never been revealed who A was. The issue was whether, in accordance with the terms of the will, she had provided security within the period of 6 months of the death of the testator, who had died on the between 8 and 9 p.m. on the 12th of January, 1805. She actually executed the security at about 7 p.m. on the 12th of July. The question was it in time, the 12th of January to the 12th of July, or out of time? Well, Sir William Grant held at pages 253 to 254, my apologies, you'll find the report at page 191 in the bundle, and the reference I've given is to the internal page reference, 253 to 254. The Master of the Rolls framed the issue for decision as to whether the day of Sir John Leicester's death is to be included in the 6 months or excluded. If the day is included, she did not. If it is excluded, she did give the required security before the end of the last day of the 6 months, and therefore did sufficiently comply with the condition. He went on, pages 2454 to 255, to consider a number of authorities, and then referred to the observation of Mr. Sergeant Palmer, who appeared for the trustees, namely that the act done, for which the computation of time is made inclusive, was an act to which the party against whom time runs was privy. We refer to that as the narrower basis of the decision. Sir William Grant said that that narrower basis applied correctly to all the cases relied on by the trustees, except the King and Adderley, which is in the bundle at page 39, at tab 39, page 398. I'm not going to go to it. Sir William Grant said that in the case before him, the event was one totally foreign to the party. And then at page 257, having said it was not necessary to lay down any general rule, a point highlighted by Miss Dixon and Mr. Broomfield, he nevertheless did go on to lay down a rule, because he said, upon technical reasoning, I rather think it would be more easy to maintain that the day of an act done or an event happening ought in all cases to be excluded than that it should in all cases be included. Our law rejects fractions of a day more generally than the civil law. The effect is to render the day a sort of indivisible point, there we have that phrase again, so that any act done in the compass of it is no more referable to any one than to any other portion of it. But the act and day are coextensive, and therefore the act cannot properly be said to be past until the day is past. This reasoning was adopted by Lord Rosslyn and Lord Thurlow in the case before mentioned in Mercer and Ogilvy. The ground on which the judgment of the Court of Session was affirmed by the House is correctly stated in the 4th volume of the Dictionary of the Decisions of the Court of Session. In the present case, the technical rule forbids us to consider the hour of the testator's death at the time of his death, for that would be making a fraction of a day. The day of the death must therefore be the time of the death, and that time must be past before the 6 months can begin to run. The rule contended for on behalf of the plaintiffs has the effect of throwing back the event into a day upon which it did not happen, considering the testator as dead upon the 11th instead of the 12th of January. For it is said, the whole of the 12th is to be computed as one of the days subsequent to his death. There seems to be no alternative but either to take the actual instant or the entire day as the time of his death, and not to begin the computation from the preceding day. Now, our submission is that what Judge Hodge and the Court of Appeal have done is exactly what Sir William Grant warned against in the passage I read a moment ago. Their decisions have the effect of throwing back the event being the accrual of the causes of action, into a day upon which they did not arise. Move on from that decision.
Sorry, Mr. Cousins, I do apologise. Could I just go to page 195 of the bundle and that
Yes.
part of Leicester against Garland, where the paragraph starts by saying it's not necessary to lay down any general rule.
Yes.
And then refers to technical reasoning. And it would be, then sets out what you describe as the general rule.
Yes.
But the justification for that appears to me to be that the rejection of fractions of a day, which then leads on to another question, and that is, if the cause of action occurs at the very moment of the start of the 3rd of June, is there genuinely a fraction of a day?
My lord, yes. But may I come at it this way, by going back to what I said a little earlier. The cause of action, a date must be identified for the cause of action having accrued, because otherwise it wouldn't be possible to apply the Limitation Act. The Limitation Act only works by prescribing a period from a particular date. So the date has to be identified. And it simply cannot have been the 2nd of June, in this case, that the cause of action arose, because throughout the whole of the 2nd of June, it was possible for a valid claim to be submitted under the scheme. So we say that Judge Hodge was right when he said it accrued at the very first moment of the day, but the day was the 3rd of June.
But the reason for the general rule is that our law rejects fractions of a day. Why should there be a rule where there isn't a fraction of a day?
My lord, if the cause of action occurs at the very first moment of the day, or at the very last moment of the day, it nevertheless still occurs on the same day. It's part and parcel of the day. The day is a united, seamless whole. My lord.
But
Can I just see if I've understood what you've there submitted? I think you were asked the question by my Lord, Lord Stevens, can we realistically talk about a fraction of the day on the facts of our case? Your answer, as I understood it, was once you've decided that the cause of action accrues on the 3rd of June,
Yes.
you inevitably are talking about accrual on a fraction of a day, because the nanosecond is a fraction of the day. Is it? Am I right?
Well, my lord, it's not the way we put it. What we say is that is that it arose at the very first moment of the day, but it arose on that day, because the very first moment of the day is the day.
But I think it was being put to you that that might be a general rule that applies where you're talking about fractions of a day. And so I think you're being asked, how is what you're saying consistent if one might be taking the view that there was no fraction of a day? And are you saying, well, it's impossible not to have a fraction of a day if a cause of action accrues on that day?
Sorry, I apologize if I'm repeating myself here, but what we say is that can I tackle it in this way? Even if one were to compartmentalize a day impermissibly on the authorities and say it's the first fraction of the 3rd of June, it's nevertheless the 3rd of June, not the 2nd of June. And that's what matters. That's the way we put it. But
I think that was the way I was putting it to you, and you didn't seem entirely sure whether that was correct. I'll just say it again, that my understanding is that once you've decided that the cause of action accrues on the 3rd of June, you are accepting logically that part of the fraction of that day has been used in effect for the accrual of the cause of action.
Well, my lord, let us put on one side legal theory for the moment. That, of course, is the reality of the situation, because if in a totally different kind of case, say a motor accident case, an accident occurs at 9 o'clock in the morning, at 8 o'clock in the morning there was no cause of action, and the cause of action accrued partway through the day. So we have a day during which no cause of action subsisted, and then later in the day the cause of action subsisted. But for limitation purposes, the whole of the day of the accident ranks as the day from which limitation is to be calculated. So if you have an accident on the 8th of June 2015, and it's a personal injury case, the claim can still be issued on the 8th of June 2018. We have an instance of that in Marin.
I thought, in effect, that you were accepting, consistent with your argument about scintillas and metaphysics, that the 3rd of June was in fact indivisible. But regardless of that, it was still the day upon which the cause of action arose. That's what I understood your argument.
Yes, my lord, that is our argument.
Yeah.
That is our argument.
And that depends upon the word from,
Yes.
as a matter of statutory interpretation. And so you would disagree with Pew against the Duke of Leeds, that from is can mean either inclusive or exclusive.
My lord, with respect, no, we don't. It's all going to depend on the context.
Yeah.
And there are cases, in fact, following, Mr. McNall is going to mention one, the case of Ind Coop, Trow and Ind Coop. There are cases where different words can lead to a different result. Trow was a case, I don't want to trespass on Mr. McNall's submission, but Trow was a case which was concerned with the validity of a writ under the rules of the Supreme Court. Now, in Trow, a different result was reached. The time ran inclusively in that case. So it was not permissible to serve a writ issued, I can't remember the day, but it wasn't permissible to serve a writ issued on the 8th of September 1965 on the 8th of September 1966, because the word was to be read inclusively, because the following word was within a period, or sorry, the words were within a period of 6 years from that date. rather than simply from that date. And the Court of Appeal distinguished the line of authority that I've been taking the court to on the wording of the relevant rule of the Supreme Court. And I don't for a moment submit that Lord Mansfield was wrong in his interpretation. The context of the lease and the wording of the instrument under which it was created all indicated that the first day should be inclusive. But those sorts of considerations don't apply in this context, and in no time limitation case, except Gelmini, has any such inclusive approach to the reckoning of time been adopted. Quite the reverse.
Thank you.
May I move on very quickly over our paragraphs 15, 16, and 17 of the written case? We've mentioned a number of later 19th century cases there. They're all in the bundle. I don't propose to go to any of them. Each of those cases was approached by the court on the basis that the day of the relevant event was to be excluded from the reckoning. I come then to a criminal limitation case, Radcliffe and Bartholomew, which was a decision of the Divisional Court in 1892, a prosecution under the Prevention of Cruelty to Animals Act 1849. A complaint had to be made within 1 calendar month after the cause of complaint arose. An information laid on the 30th of June 1891 was held to be within time in respect of an incident which occurred on the 30th of May of that year. Lester and Garland was not actually, it seems, cited to the court, nor was it relied upon in the judgment of Mr. Justice Wills, who delivered the only substantive judgment, which I should say is at page 214 of the bundle. But the principle which was applied by the court in that case was the broader one identified in Lester and Garland, namely that the case was in time because the date of the alleged offence was to be excluded from the reckoning, the court holding that no distinction should be drawn between civil and criminal cases for that purpose. May I then come on to the Goldsmiths Company and West Metropolitan Railway? It's at page 233 in the bundle. In that case, the issue was whether, as required by the terms of a statute passed on the 9th of August 1899, a notice to treat for compulsory purchase given on the 9th of August 1902 was given within 3 years from the date on which the Act was passed. The Court of Appeal, dismissing the appeal from Mr. Justice Walton, held the notice to be valid, and the Master of the Rolls said at page, this is internal, page 5 of the report, it appeared to him that no distinction could be drawn between the day determined by the passing of the Act and any other day from which time might be reckoned. If this view is correct, the day from which the period is to run must be excluded in computing the 3 years. And Lord Justice Matthew at internal page 5 went on to refer to Lester and Garland and later authority. And he said this: the rule is now well established that where a particular time is given from a certain event within which an act is to be done, the day of the date is to be excluded. Now, it's convenient to mention at this point, although it involves a departure from the chronological consideration of materials, that Goldsmiths was considered in Stewart and Chapman, another divisional court case in 1951, raised an issue of whether a notice of intended prosecution required under Section 21 of the Road Traffic Act 1930 had been given within 14 days of the commission of an offence. The alleged offence was on the 11th of January 1951. Service took place on the 25th. Lord Goddard reviewed the history of the authorities at the foot of internal 796 to 799, and he acknowledged the Master of the Rolls observation in Goldsmith that the rule concerned and confirmed in that case was well established by 1903, and he cited the passage which I read a moment ago from the judgment of Lord Justice Matthew. And he observed that the decision in Goldsmiths was binding on the Court of Appeal. Can I then come to what we say is the outlier here, the case of Gelmini? Mr. Justice Channell's decision in 1913. It was a case followed by all the judges in this case below. Gelmini raised two issues for consideration. One was the effect of the court office being closed on the day upon which a limitation period expired. That's not something which need trouble this court today. The second issue was relevant to what we're considering, namely whether the last day for payment of a promissory note was the 22nd of September 1912, when where that was the last day for the payment of a promissory note. A writ issued on the following Monday, the 24th of September, was in time. And we set out in our written case what Mr. Justice Channell reasoned at pages 552 to 553. And in short, his lordship's reasoning was this, that an action couldn't be brought until the cause of action was complete. And in all cases of contract, the person who has to pay has the whole of the day upon which payment is due in which to pay. And therefore, until the expiration of that day, an action cannot be brought, because until then there is no complete cause of action. Well, we agree with that. He went on to say that the result is that an action can't be brought until the next day, but it can be brought on that day, because it's complete at the commencement of the day. And so throughout the following day, there is a valid cause of action. And it was that reasoning which appealed both to Judge Hodge and to the Court of Appeal in this case. But could I just emphasize these words in the cited passage in Mr. Justice Channell's judgment? He said, "I do not think that the day on which the cause of action arises is excluded." Now, he hadn't been referred to Radcliffe and Bartholomew, but it is clear from that he was not purporting to follow any rule of law to the effect that the day should be excluded. And that we submit is material, because it was a deliberate decision to depart from what was, per the Goldsmith case, already a well-established rule of law. We come on then to later authorities which develop and demonstrate the rule and its authority. And I'm moving on to paragraphs 22 to 32 in our written case. I've mentioned Stewart and Chapman already. And there are a number of other cases, Cartwright and McCormack, Ladyman and Wirral Estate, in re Figgis. They all deal with different problems: construction of an insurance policy, the construction of a lease is to a term, and the construction of a will is to a period of survivorship.
Mr. Cousins, sorry to interrupt, but just before we leave Gelmini,
yes,
Is your submission that, I mean, clearly what's been put against you is that this is an exception because it's a midnight deadline case?
Yes.
I think you've already told us that this case is an outlier. Have there been any other cases which have considered the midnight deadline position prior,
No, my
obviously,
lord.
to the Court of Appeal in this case?
No.
Right.
Gelmini was the first, and as far as we're aware, it's the last before this case.
Right. And is your submission that in Gelmini, they're not making anything of the midnight deadline point, but rather that Mr. Justice Chanel is just stating a rule that is actually an incorrect rule, because we know that the general rule is that you exclude the day on which the cause of action accrues. And
Yes.
he's not saying, oh, there's an exception here because it's a midnight deadline case. Is that the point, that he's making a bold proposition that is actually, we know, to be incorrect?
Yes, that's our submission. It's unsupportable on the authorities. I'm going to say something, and it is very much a footnote, perhaps it's an interesting one, about the legal history of the status of the divisional court a little bit later. I will be brief on that. But whether or not Mr. Justice Channel was bound by Bartholomew doesn't really matter, because it's perfectly clear on the authorities that we've already looked at that there was a well-established rule about excluding the day of the event. And it was well established by 1903. We would say it was really authoritatively established, if not before, in 1796 in Mercer. But it's been applied time and time again in the context of calculating time under a statute when working out when a period runs from.
But in a sense, for your point, it doesn't matter whether it was wrong at right or wrong at the time. We know it's wrong today because the general rule is quite clear.
Yes, my lord, I do make that submission. Can I just mention this point now, since we've actually dwelt upon it for a moment? We say it doesn't matter. Of course, it doesn't matter in this court whether or not Mr. Justice Channel was bound or not bound by Radcliffe and Bartholomew. In Maron and Dawson Bentley, the case I'm going to come to next, Mr. Justice Havers said that Mr. Justice Channel was bound by Radcliffe. We've looked at this quite carefully, and I've got to say, I think we misstated the position in our written case. But Mr. McNaull and I were concerned about this, and we've dug through the authority, and I think we've got to the bottom of it. We don't think that he was bound by Radcliffe and Bartholomew. When Mr. Justice Havers said that, the most recent authoritative decision on the status of a divisional court decision on another High Court judge in a subsequent case was a pronouncement of Lord Goddard in the divisional court in 1947. He said that it was binding. In 1985, the divisional court revisited that topic, and the court presided over by Lord Justice Robert Gough, as he then was, differed from Lord Goddard and explained why. And there are a number of reasons for why. But compellingly, it seems that actually Lord Goddard's decision in 1947 hadn't taken into account earlier decisions of the divisional court back in the 1890s, which rather suggested contrary. But that's just an interesting footnote of legal history. We actually set out the authority on this topic in our so we haven't set out in the written case. Could I just tell you where it's to be found? It is in the additional materials. at page 783, it's the police authority for Huddersfield and Watson. That's the Lord Goddard pronouncement. And the case which departs from that and sets out the modern approach is the Crown and Greater Manchester Coroner at 791 in the bundle. Now, I will just add, for the sake of completeness, we have inserted at page 774 in the bundle an extract from the Supreme Court Practice 1999, which discusses this very point. Unfortunately, that note hasn't found its way into the current practice, but it is, as far as Mr. McNaull and I have been able to discover, a correct statement of the law. So what we say is that as a matter of judicial comity, at the very least, Mr. Justice Channell should have followed Radcliffe and Bartholomew, but he was bound by the Goldsmiths case, if bound by nothing else. I note the time. I was going next to come on to Maron. Would it be convenient to break for the 5 minutes mentioned earlier at this point?
Yes, you indicated that Mr. McNaull was also going to be addressing the court.
Yes.
Yes, you have till 12:30.
Yes,
yes. Well, okay.
We're very conscious of that.
Yes, we'll adjourn now for 5 minutes. Thank you very much.
Thank you, my lord. Before
Mr. Cousins, you may resume your submission. Thank you.
I'm very grateful. Before I do so, may I just say, in answer to my lady's question this morning, Mr. McNaull points out that the scheme itself is at page 767 in the supplemental bundle.
Thank you.
I'm going to turn now to Maron, and I can take this fairly shortly. The case arose from a fatal accident on the 5th of September. The case arose from paragraph 26 of our written case. It arose from an accident, not a fatal accident, on the 8th of November 1954, where the plaintiff suffered personal injuries. His writ claiming damages was issued on the 8th of November 1957, and it was alleged to be statute barred. Well, I might think it's fairly remarkable that it had taken until 1957, since the 1623 statute of limitations for this point to arise for the first time, but so seems to have been the case. And Mr. Justice Haber's finding for the plaintiff rejected the contention that the claim was barred. At page 138, he said there was a lack of authority directly on that point under the 1939 Act, although there were a number of authorities under earlier enactments which contained provisions of a similar character. And then he went on to set out a passage. This is set out in our written case as well, from the then current edition of Halsbury. It's headed "Period within which an act must be done." Continues into paragraph 208. And may I cut it short and put it this way? What Halsbury describes is what we have been describing as the long-standing rule. Mr. Justice Havers went on to consider Gelmini, pointing out a number of earlier authorities, which are in the bundle and mentioned in our written case, including Radcliffe and Bartholomew. And his conclusion was that Radcliffe was of general application to statutes, paragraph 28 of our written case, whether they deal with civil or criminal matters. And he then said he thought that the divisional court decision was binding on him and was of general application, but he did say that he would have preferred that reasoning in any event over that in Gelmini. Moving on from Maron, we come to a decision of the Court of Appeal, which is in the bundle at page 293. And it's the case of Pritamcourt and Russell, Lord Denning, the Master of the Rolls, and Lord Justice Karminski, and Mr. Justice McGarry, as he then was. Fatal accident case, accident on 5th of September 1967, writ issued on the 7th of September 1970. There was an issue about the cause of action expiring over a weekend, and the court office point arose and was determined in favour of the plaintiff and is not in issue now. But when it came to deciding whether or not the claim was barred, what Lord Denning said at page 348E in the report, the internal numbering, was that Mr. Justice Haver's decision was plainly right. And he said, you do not count the first day. Lord Justice Karminski agreed entirely with Lord Denning, 349H, and Mr. Justice McGarry agreed in the substantive judgment that the day of the accident should be excluded. We get that at 350H. Our submission is that the express approval of the decision in Maron therefore carried with it implicit disapproval of the decision in Gelmini. We say that whatever the position may have been prior to the decision in Pritamcourt, the position under the Limitation Act was made absolutely plain by the 1973 decision of the Court of Appeal. But it wasn't really laying down any new rules at all. It was simply applying the long-established rule. May I then turn to the judgments in the present case, the judgment of the Court of Appeal in the present case. I've mentioned briefly already how Lord Justice Irwin, paragraph 17, accepted that the day of accrual of a cause of action is to be excluded, and how English and Welsh law disregard the fractions of a day. But, and I do need to go to this because it is just important to see the way he put it. If I could invite the court to look at the decision of the Court of Appeal, and what Lord Justice Irwin said at paragraph 16. He said this: it seems to me that the better view, therefore, this was having referred to Dodds and Walker, which I'll mention in a moment, the better view, therefore, is that in the case of a midnight deadline, it is wrong to attribute the accrual of an action such as this to the day after the relevant midnight, and the analysis must proceed from there. Now, in our submission, that was the wrong approach. He said he had based it upon Dodds and Walker, or he had taken Dodds and Walker into account in reaching that view. And he dealt with Dodds and Walker at paragraph 15. Dodds and Walker, I will just add, Dodds and Walker wasn't referred to in argument in the Court of Appeal, and it wasn't cited, it wasn't mentioned in the course of the hearing. It was first raised in the judgment of the Court of Appeal when it was sent out. Dodds and Walker was a case under the Landlord and Tenant Act 1954, and what it concerned was whether a counter notice had been, whether an application for a new tenancy had validly been made under the Act, where the notice given by the landlord had been given on the 30th of September 1978, but the tenant's application was made on the 31st of January 1979. It was a 4-month period, of course, under the Act for the making of an application. Lord Diplock with whom all of their lordships agreed, though Lord Russell delivered a short concurring speech. Lord Diplock said that the case could be decided simply by the application of the corresponding date rule. That is to say, if there is a 2-month period to do something and the relevant time begins to run from the 20th of the month, then you have until the 20th of the month, which corresponds 2 months later, to do the act, but no longer. And so he held that the application to the court was out of time. In our submission, no comfort or support is to be, no support for the decision of the Court of Appeal can be taken from the decision of Dodds and Walker. In paragraph 15 of his judgment, Lord Justice Irwin cited this passage from the judgment of, from the speech of Lord Diplock, who said in Dodds, "My lords, I do not personally derive assistance from pursuing metaphysical arguments about attributing to one day or the other the punctum temporis between the 2400 hours on the 30th of September and 0000 hours on the 1st of October, at which time began to run against the tenant. These seem to me to be quite inappropriate to the determination of the meaning of a statute which regulates the mutual rights of landlords and tenants of all business premises and is intended to be understood and acted upon by them." The case was simply decided and resolved upon the application of the corresponding date rule. It was inevitable that the application made on the 31st of January should be made out of time, should be held out of time. But it seems that the argument for the tenant was that since the 30th of September was the last day of 1 month, then the tenant should have had until the 31st of January, the last day of the corresponding month, 4 months later. But Lord Diplock didn't actually deal with that point in his speech, but it is answered, we would submit extremely compellingly in the Court of Appeal, and I'll have to refer you to the supplemental bundle of authorities, by Lord Justice Templeman, as he then was. You'll find the report in the Court of Appeal at page 811 in the bundle. And Lord Justice Templeman, as he then was, made this point at page 817 of the bundle, 1067 of the internal page numbering. He said, if the landlord had served his notice on the 29th of September, the last available date for the application by the tenant would admittedly have been the corresponding 29th of January. The landlord served his notice on the 30th of September, and therefore the last available date was the corresponding date, January the 30th. By claiming that his last day for application was 1 day later, the 31st of January, the tenant is breaking the corresponding day principle and attempting to compensate himself for the non-existence of the 31st of September. We would submit what Lord Justice Templeman said has got to be right. If something happened on the 15th of the month, the corresponding date rule takes us to the 15th of another month, not the 16th or the 17th or the 18th. So we submit that really Dodds and Walker does not tell us much of relevance about how this case should be decided. Other than that, it shouldn't be by way of resort to a punctum temporis. Lord Justice Irwin, at paragraph 30 of his judgment, referred to Gelmini and to a passage from the 7th edition of McGee, which you will find in the bundle. He appears to have approved and adopted Professor McGee's attempt to reconcile Gelmini and Maron. on the basis of an ostensible rule that any part of a day but not the whole day happening after the cause of action accrues is excluded from the calculation of the limitation period. We say that the interpolation of the words "but not a whole day" has no statutory warrant whatever. There is nothing in the way that the Act is drafted to justify that interpolation of wording. And it's never been identified in any case until this one, unless one construes what Mr. Justice Chan did in Gelmini as to similar effect. We submit
but
that
is it a
Lord
question?
Justice...
Could I just ask, is it really
Yes,
a question of a textual approach? Or does one have to ask what the purpose of the rule is? And the purpose of the rule is that somebody should have the requisite number of whole days. And if you've got a fraction of a day, that obviously can't happen. There are other practical problems about fractions of a day because you might have a small fraction or a large fraction. But if you can satisfy yourself that a party has been given the requisite time period, what is the rational rule for exclusion of the first day?
My lady, I can see the force of that argument, but if I may say so, the rational justification now for continuing the application of the rule, as it has been understood that the running of time should be calculated since the 18th century, is that it's how it always has been done. And in relation to something as important as limitation, it is desirable that there should be continuity of interpretation.
Yes, but there are obviously problems about that, because it might be said, and has been said by people like Oliver Wendell Holmes, that if you can't find the reason for a rule, maybe you shouldn't have the rule.
Well, my lady, I'm sorry. I can't do better than go back to what was said in Mercer, because a very good explanation was given in the speech of Lord Thurlow, which I read earlier this morning, and we have set it out in our submission at paragraph 11, where Lord Thurlow said that the terminus a quo is descriptive of a period of time and synonymous with the day, with the date or the day of the deed. Substitute, in this case, the accrual of the cause of action, which is indivisible. And 60 days after is descriptive of another and subsequent period. So it's a general rule of construction which is logical and which has been consistently applied since the late 18th century. And in our submission, there is no reason today to depart from that rule. But there is no way, we would submit, of reconciling the judgment of the Court of Appeal in this case with the earlier authority. One can't do it on the basis of the date, because if the cause of action can only accrue on the 3rd of June, it is simply impermissible, effectively, as Lord Justice Irwin has done, to deem it as having accrued on an earlier date. Time runs from the 3rd of June.
But it may be that the earlier authorities are not all of one voice.
My lady, it may be that there are some authorities that are concerned with the interpretation of a provision in a will or the interpretation of a lease, where the wording or the context is different. But here we have a statute of limitations which has been construed, and statutes of limitations have been construed on quite a number of occasions. And the conclusion reached, save in Gelmini, is that an exclusive approach is to be adopted in the case of limitation. And it is difficult to see any justification now for departing from a rule so long established and which has been held by a number of courts to be a binding rule after so long a period.
Sorry, Mr. Cousins, just in relation to that quotation from Mercer,
yes,
a quo mentioned in the Act is descriptive of a period of time and synonymous with the day or date of the deed, which is indivisible. Well, in that case, they were dealing with a date which had been divided. So isn't it just another example of the law that you do not deal with fractions of a day? What the case did not relate to, as far as I understand it, and correct me if I'm wrong, it did not relate to a situation where one had the whole day. This was a situation where there was a division of a day.
My lord, I see the force of that, but if it is appropriate, if there is a rule that the day of an event is to be excluded in calculating the running of time, then in this case the event was the accrual of the cause of action. And it doesn't matter if the rule is correctly formulated and has been correctly applied in all the cases that we've mentioned. It doesn't matter whether it's a second after midnight, a nanosecond after midnight, or at the other end of the day.
Thank you.
May I?
The answer to that point that as by operation of law, there was no question of a nanosecond. The cause of action accrued for the entirety of the day, and that if it had been possible to serve process or to file process the moment midnight struck, it could have been filed.
My lady, in this case, certainly, I used the example of a situation where the court office is open all day long. It could have been filed, but it would have to be the 3rd of June before it could be filed.
But at any stage?
Yes, it could have been filed at any time during the 3rd of June.
With electronic filing, you can do it any time.
Yes, that is so. Of course, the cases that we've been looking at are cases where the earlier authorities were concerned with cases where a court office had to be open for a writ to be issued. But in our submission, a change in the procedure for filing ought not by a side wind to affect something as fundamental as a limitation statute. May I go to the judgment of Lord Justice Underhill, which we deal with in our written case at paragraph 39. Lord Justice Underhill at paragraph 39 acknowledged that he couldn't see any rational basis on which to distinguish between fractions of a day that are or are not sufficiently big to count. But we submit that his conclusion necessarily involves interposing some unit of time between the 2nd and the 3rd of June. In other words, it involves the creation of a scintilla of time, or it involves throwing back the accrual of the cause of action, in the words of Sir William Grant, to the day before it actually accrued. I'm not going to repeat again why I have submitted already that the cause of action can't have accrued on the 2nd of June. I'm conscious of the time and that we must be finished by 11:30. If I may, I will deal with the authorities that I know Ms. Dixon is going to rely upon when it comes to reply. And I will, if I may now, pass over to Mr. McNaull.
Oh, Mr. Cousins, thank you very much for that. Mr. McNaull.
My lords and my lady, in the time available to me, I propose to address your lordships and ladyship briefly in relation to two matters. The first is the decision of the Court of Appeal in Trow and Coop in 1967. The second are authorities and materials from jurisdictions other than England and Wales. Dealing first then with the decision of the Court of Appeal in Trow and Coop, for your notes, this is to be found at page 704 of the additional authorities. You have already had the submissions of my lead in relation to the meaning and importance of the word date being embedded within the Limitation Act. I would like to reinforce those submissions with reference to Trow. Trow is an instructive case. It's perhaps not always been afforded the attention it deserves. It was a composition of the Court of Appeal of Lord Denning, the Master of the Rolls, Lords Justices Harman and Salmon, on appeal from Mr. Justice Blaine. In the Court of Appeal, it was fully argued by Gordon Slynn on the one side and Brian Gibbons of Queen's Counsel, leading Stephen Tumin on the other side over the course of 2 days, and the court's decision was reserved. As the head notes make sufficiently clear, the narrow point immediately at issue in Trow was whether a writ issued timelessly at 3 o'clock on the afternoon of the 10th of September 1965 and served at noon on the 10th of September 1966 was served within 12 months, beginning with the date of the writ. That was consideration of the effect of the then version of Order 6, Rule 8 of the Rules of the Supreme Court. It was held by Mr. Justice Blaine and by the majority of the Court of Appeal, with the Master of the Rolls dissenting, that the writ was served out of time. But that was on an application of the particular wording of the rules of the Supreme Court, and particularly the words beginning with the date of the writ, which are not the same as the words used in the Limitation Act. As the Master of the Rolls recognised, there was a broader point in the case that the time for service was very like a period of limitation. And the Master of the Rolls undertook a careful and scholarly review of many of the authorities on limitation to which you've already been referred this morning, beginning with the decision of Lord Mansfield in Pugh and the Duke of Leeds in 1777, and the decision of Sir William Grant, the Master of the Rolls, in Leicester and Garland in 1808, Lord Denning identified at page 913 of the report, appearing at page 718 of the hearing bundle, that the key dispute was whether the decision of Mr. Justice Channell in Gelmini and Meridia or the decision of Mr. Justice Havers in Marin and Dawson should be preferred. And the Master of the Rolls was clear that he would have preferred the approach of Mr. Justice Havers in Marin. Importantly, for present purposes, there is a section of that of the judgment of Lord Denning, beginning at page 914, internal page 914 F of the report, which is at page 719 of the hearing bundle, when Lord Denning says this: when we speak of the dates on which anything is done, we mean the dates by the calendar, such as the date today is January the 19th, 2021. We do not divide the dates up into hours and minutes. We take no account of fractions of a date. If authority were needed for so obvious a proposition, it can be found in the judgment of Lord Mansfield in Pugh and Duke of Leeds. So applying that, Lord Denning's approach was the whole date of the date of issue must either be included or excluded in calculating the 12 months. He then goes on to consider whether with and from were the same. He does say at page 916, at letter D, which is at page 721 of the hearing bundle, he goes on to consider and approve the leading case of Leicester and Garland, and the passage already referred to from the decision in that case of Sir William Grant, the Master of the Rolls, and notes that the reasoning of Sir William Grant in Leicester and Garland was afterwards adopted by many great judges in the 19th century, including Lord Tenterden and Baron Park, where the earlier cases were disapproved. And Lord Denning carries that reasoning through to consider the authorities to which you've already been taken, and the then most current edition of Holsbury. In this regard, Lord Justices Harman and Salmon agree with Lord Denning, Master of the Rolls, although departing as to the outcome on the basis of the wording of the rule of the Supreme Court. Lord Justice Harman at internal page 918F, which is page 723 of the hearing bundle, again expressly refers to Leicester and Garland and appears to approve of it. At page 920F, which is hearing bundle 725, Lord Justice Harman says, as to the word date, I think counsel for the respondents was again right in saying that this word means a division of time shown on the calendar and does not refer to any particular time of the day. There was similar reasoning from Lord Justice Salmon. So we say that Trowen in Coop, although not ostensibly a case on the Limitation Act, nonetheless provides useful guidance as to the meaning of the word date. Permission to appeal was refused by the Court of Appeal in Trow and in Coop. But of course, had it been granted, then perhaps it would have brought the very point before the House of Lords in the 1960s with which the court today is concerned. But we say the decision of the Court of Appeal and the reasoning of the composition of the Court of Appeal in Coop provides still further support for the approach which the present appellants urge this court to adopt. That is to say, a proper focus on the date on which a cause of action accrued. My second point, I'd like to conclude my submissions with some remarks as to the comparative approach, and particularly the matters dealt with at paragraphs 47 through to 56 of the respondent's written case. The legislation in issue here, the Limitation Act 1980, does not draw any distinction in the law of England and Wales between the commencement of the running of the limitation period based upon the point during a day when the relevant accrual occurs. And I invite your lordships and ladyship to consider that it is significant that none of the acts from other UK jurisdictions or from our sister common law jurisdictions show that any legislature anywhere has sought to expressly articulate in relation to limitation a midnight deadline exception or carve out from the usual rules of limitation. The legislation from different jurisdictions adopts different approaches. Sometimes a day is included and sometimes it is excluded. But there is nothing in the legislation from any of our sister jurisdictions which says that if a cause of action accrued on a particular date, let's say the 3rd of June, that the court nonetheless would have the power to deem it in fact accrued on some different date. So we agree in broad terms with the respondents, paragraph 56 of the respondents' written case, that the applicable principles differ from jurisdiction to jurisdiction, and except to show the absence of a consistent approach across all jurisdictions, are of limited assistance in the interpretation and application of the law of England and Wales. My lords and my lady, unless I can assist the court further, those are my submissions, and I adopt those of my leader.
Mr. Wicknell, thank you very much for that succinct presentation.
I'm obliged.
Ms. Dixon, would you like to begin your submissions? Ms. Dixon, I for one can't hear you. I don't know if my colleagues can. No, none of us can. Perhaps you better have a word with our IT department to sort out that difficulty. Ms. Dixon, I'm glad we've been able to resolve the technical glitch, which meant we couldn't hear from you, but we now can. So I invite you to start your submission.
I'm grateful. I believe it's the phrase of 2020, which is, can you hear me, or you're on mute. And I managed to fall into both those traps at the same time. But I'll begin again with, to say, as per our written submissions, which we adopt in full, our oral submissions will focus on two broad questions. The first is, when did the cause of action accrue? And what we say in 30 seconds, which I'll then expand on over a much longer period of time, is we say that it is the end of the last moment of the 2nd of June. That's the first section of my submissions. The second section of my submissions will be, if we are wrong on that, and it is the 3rd of June, and I would say it is the beginning of the very first moment of the 3rd of June, then should that day be excluded when calculating the limitation period? And that will come on to look at some of the points you've touched on already with Mr. Cousins, the existence or otherwise of a general rule, the rationale for that general rule, if there is one, and whether it should be applied in cases of midnight deadlines. So my lord and my lady, that is the structure I intend to follow, and beginning then with when did the cause of action accrue? If I can start by a point of clarification, perhaps because of the nature of the hearing I didn't feel it appropriate to intervene, that this claim is actually only brought in for breach of trust and for negligence. It's not a breach of contract claim, and I can make that good if I need to from the particulars of claim, which you'll find in your supplementary bundle at page 743. Well, Lords, I'm conscious that you will be dealing with electronic PDFs. I'm not sure how many PDFs you have, and I'm not sure whether they are numbered in the same way. So I'm going to stick with the hearing bundle number, but I am armed with a laptop with the PDFs, and if you need me to give your pagination references in some other way, then please let me know. But for present purposes, the particulars of claim begin at page 740, and the duties are set out on page 743 under the heading Defendant's Duties. It's a short point, and I don't say that it takes me anywhere at all, but I just wanted to correct it since my Lord Borough has asked the question. And at paragraph 18, there is a reference to the Trustee Act and the duties of the trustees, the defendants being trustees. And at paragraph 19, as a further or alternatively, a general duty to administer with reasonable skill and care. And so that is, I claim, then articulated in tortious duty. And that translates into the allegations of breach. And they are set out on page 747 and set out in terms negligently and or otherwise in breach of duty. So to correct my lord what was said, this is a case concerned with breach of trust or negligence. As I say, I don't say that anything turns on that, but that is the position on the pleadings at least. If I can then focus with intensity on identifying the moment in time when the cause of action accrued. My late Lady Arden asked if she could see the scheme documents, and it would be a convenient moment perhaps to look at them. And they are at they start at page 767. You don't have, because there's absolutely no need for you to see, in my submission at least, the entirety of the welcome scheme, but you have some of the key clauses. And if I can ask you to turn to page 773 of that document, you'll see that there are a couple of clauses which are of relevance to this action. 3.5.3, claim forms must be sent to scheme supervisors to arrive on or before the bar date. 3.6, requirement to submit claim form, subject to clause 3.7.2, which is not material. In order to be entitled to any payment scheme, scheme creditors must, on or prior to the bar date, submit a claim form. No payments will be made in respect of scheme liabilities that are not submitted as submitted scheme claims. And that is it. Takes one no further than that. But against that background, I'd like to address what the nature of this claim is. And we say that for the purposes of this section of our submissions, it's important to focus on the fact that this is negligence by omission. To submit a claim in the welcome scheme, the claimants had to submit a claim form on or prior to the 2nd of June 2011. I'm a little concerned with the overuse of the words claim form here. We obviously have claim form in two scenarios. I'm sure you've appreciated that. The scheme uses the wording claim form, and there are obviously claim forms in the action. Scheme's purpose, there had to be submitted a claim form on or prior to the 2nd of June 2011. There's one allegation of breach pleaded in relation to the welcome claim, and that is that the defendants failed to make any claim in the welcome scheme before that scheme's bar date. As simple as a cause of action could be, in the sense of a failure to do something by a specified and immovable date. So we say, as a consequence of that two things happened at precisely the same moment. And this is a point which was attacked by Mr. Cousins this morning, and I'll come on to the attack that he made. We say those two things are this. Firstly, at precisely the same moment that the time for submitting the claim in the welcome scheme passed, the claimant's cause of action against the defendants arose. In other words, as soon as it was too late to put in a claim, the moment had passed. At exactly the same moment, a cause of action arose against the defendants who had failed to put in that very claim. Now, we say that these are not consecutive events. They are inextricably linked and occurred simultaneously. Now, I don't consider I need to take you to them, but in our written case, we referred to two authorities in admittedly completely different factual scenarios, but which make a point on which I rely. And those are English and Cliff and Abbey National and Cannes. And perhaps the best known Abbey National and Cannes, as you'll be more than well aware, was concerned with a case where there was a purchase of a legal estate and a charge in favour of the lender, and a question arose as to whether they were consecutive events or whether they happened at the same time. And the finding in that case was that there was no scintilla temporis. I'll come back to that. We don't rely on scintilla temporis in this case. But importantly, that they occurred not only precisely simultaneously, but were indissolubly bound together. Now, Mr. Cousins attacked the use of our language in the respondent's case of being indissolubly bound together. It was used precisely because that was the language in Abinational Can. There are situations where the law recognises two things are just happening at the same time. And we say that this is precisely one of those occasions. As time elapsed on the making of a claim in the welcome scheme, the cause of action against the defendants accrued. They happened at the same time. Now, if that can then be contrasted with a different situation, which is when negligence arises out of a positive act. And if I may, to try and keep it within the four walls of the fact pattern that we're dealing with, you recall that I showed you the welcome scheme, and that the requirement was not only that it be submitted in by a particular date, but also that it be submitted to the scheme supervisors, and that was clause 3.5.3. So if I can hypothesize a situation where the defendants had got it in on time, but had sent it to the wrong place or hadn't submitted it to the scheme supervisors, then that wouldn't be on an omission, something which became negligent by the mere reflection of time. It would be something which was negligent because of a positive act, because they had served upon the wrong entity, not KPMG effectively. They had served upon somebody else. Now, where you have an act of negligence which comprises a positive act, then that does arise at an identifiable date and time. It doesn't occur simply because time has elapsed. Rather, you can say that this claim form was served on the wrong entity on this day and at this time. When you're looking at an act of negligence, the moment of the loss and the cause of action occur at an identifiable time and place. Now, I quite appreciate that there is a risk of being seen to dance upon the head of a pin, but it's important in this case because of the midnight deadline, why it's not a dance on the head of the pin that other people undertake. In this case, one has a deadline which expires at midnight. The defendants became negligent once that deadline had expired. They didn't have to do anything. The whole problem was that they hadn't done the thing. So time passed. The time period for doing the claim form passed. They then became, in the claimant's case, negligent. It's different to a case, and we'll look at a few, but certainly not all of the cases that the appellants rely upon. When we look at some of these cases, they are concerned with positive acts. Leases being, that's probably a bad example, but acts which happen on a particular date, notices by landlords, that kind of thing. They happen at a particular time at a particular date. Here what we have is the effluxion of time, and crucially, the effluxion of time at midnight.
Sorry, Ms. Dixon, I was interested in that distinction in this case between a positive act serving on the wrong person at an earlier stage. That cause of action doesn't arise in negligence until damage has been sustained, and that will bring you back to midnight.
Yes.
So there's no distinction, so far as I can see at the moment, between a positive act and an omission as far as the accrual of a cause of action in negligence.
Well, my Lord Stevens has perhaps picked up on the floor in my attempt to try and keep it within the four walls of the welcome scheme. But if we take it outside the four walls of the welcome scheme and we say, well, a positive act, let's say perish the thought a barrister gives an opinion on the law which turns out to be wrong, then that is an opinion which is given at an identifiable time, an identifiable date. And that is a positive act. The negligent act is the time, it occurs at a particular time, a particular date. It contrasts with this situation where the defendants didn't do anything on a particular time and date. They failed to do something by the end of a particular day. But my Lord Stevens, I take your point in relation to the particular example that I gave. So if I can focus now on this case, which as I've said is is the fact pattern is it is an omission to do something with a midnight deadline. Can I sweep away what Mr. Cousins rightly called some of the undergrowth, some of the matters on which we don't dispute and there is common ground? Some of them may seem to be truisms, but it's probably worth sweeping them away to ensure that we're all talking about the same thing. Firstly, there is no scintilla temporis between 2 days. I accept that. And that allies with the second point. Every moment in time falls into a day. There are probably 2 ways of saying the same thing. But I am not submitting, suggesting, or supporting anything which says that there is some moment of time which doesn't fall within a day. The corollary of that is there is no moment which is in 2 days. So every moment is in a day, no moment is not in a day, no moment is in 2 days. So against that background, we have to look at what is the moment that is important in this case. And in our written case, what we said on a number of occasions is, when you look at the authorities there are, everybody's trying to articulate effectively the same moment. But there is what I'm going to call a fulcrum between 2 days. Everybody is focusing on the same moment. The time to submit a claim in the welcome scheme expires, the cause of action against the defendants accrue. Now, what is that moment? And it comes at the fulcrum of 2 days, midnight between the 2nd and the 3rd of June 2011. To use an analogy, it's the flick of a switch, a light switch. As one is pressing the light switch, you exit one day. When you pass the moment, you enter the next day. But they are 2 days, 2 distinct days, but we're looking at the fulcrum between the 2 days. And again, this case risks being dancing on the head of a pin. And when I end my submissions, what I'll be saying is that whether you find that it is the end of the final moment of the 2nd of June or the beginning of the first moment of the 3rd of June, the outcome should be the same. But against that background, can I look at the case of Dodds and Walker? Because I'm conscious that Lord Justice Irwin found it of assistance in the Court of Appeal, and I'd like to look at how it helps us if it does. You'll find that in your bundle, you've already been taken to it by Mr. Cousins at page 315. Now, I believe Mr. Cousins also took you through the facts briefly, and so I won't labour those again. It was effectively about a landlord and tenant case about notice being given to a tenant, terminating the tenancy and the tenant's application for a new tenancy. Basic issue was the tenant's application 1 day too late? I'm going to ask you to go to page 316, the judgment of Lord Diplock. Now, the first point to derive starts at just above letter B. And he's talking about the corresponding date rule. Now, in my submission, there's little to be taken from this. The corresponding date rule and a general rule, I'll come on to whether it is a general rule at all, or a rule applicable in this case, but let's assume that there is an exclusionary rule here. Those two are entirely complementary. Notice on the 30th of September 78 expired at the end of Notice on the 30th of September 1978 expired at the end of the 30th of January 1979 because one begins counting from the end of the day on the 30th of September so that the whole of the 1st of October is included. So that's the corresponding date rule. It becomes a difficulty, as it did in this case, when you have uneven numbers of days and months. But other than that, it doesn't take us any further. Now, there is a single sentence on which Lord Justice Irwin found great assistance, and that's next to letter G on that page. Now, my lords and my lady, I have looked to try and find the context in which this sentence sits, because on reading it, it appears to be answering something that appears to have been put in submissions, but there's no assistance in the reported reports in this case that I found of arguments being put on this. But when one reads it, My lords, I do not personally derive assistance from pursuing metaphysical arguments. It rather reads as though somebody has put to him precisely that metaphysical argument and he is then responding to it. But I can't give this court assistance as to the context in which that arose. But in any event, what he says is as follows, and we can take a couple of points from it. We are not arguing that there is a punctum temporis between 2400 hours on the September the 30th or 00 on October the 1st. We would not argue that on the dates in this case. It doesn't either seem to be what Lord Justice Diplock is saying, either. He's saying he doesn't derive any assistance from that argument. So I assume that argument was that there was such a punctum temporis, and he's not deriving any assistance from it. And as I'll come on to when I look at the Court of Appeal decision in this action, it isn't what the Court of Appeal in this case found either. Now, if we leave aside the reference to punctum temporis, what this sentence does neatly describe and exemplify is the fulcrum point that I made a little earlier, which is 2400 hours on the 30th of September is the end of the final moment of that day, such that there is no time left in that day. 0000 on the 1st of October is the start of the first moment of the 1st of October, such that all the time in that day has yet to come. And this is a point which has been discussed by my Lord Stevens with Mr. Cousins this morning, and I will return to, which is, when we're talking about a day, what do we mean? This sentence neatly exemplifies my point, which is, we're on the fulcrum of 2 days, the point at which there is no time left on the 2nd of June, and the point at which all of the 3rd of June is yet to come. Now, against that background, and if I may, I'd like to look at the case of Gelmini. I am not, for the purpose of this part of my submissions, going to look at whether it has been disapproved, overruled, the courts with cases coming before it or after it. I just want to intensely focus on the findings in that case, because it is the case which we have where a judge, and I accept a judge at first instance giving an extempore judgment, focused on the cause of action which accrued at midnight. And I'm trying to use neutral language there. We'll come on to what he actually found now. So if we can look at the decision in Gelmini, and helpfully you have three reports for this particular case in your bundle. I am going to take you through all 3 of them. If it's of any comfort, I will be done, I imagine, by the short adjournment. So it's a 10-minute trawl through reports. So if we can start with the King's Bench Division report, and hearing bundle page 242. And without wishing to give away the punchline, what I'm going to be showing you as we go through these 3 reports is that whilst Mr. Justice Channell was very clear as to the result, there are a little waverings in the reasoning in terms of which side of the fulcrum he came down on. That's not a criticism, but what it shows is that the outcome should be the same irrespective. And for the purposes of my argument, my current limb of my argument, that there is some support for what I'm saying is the end of the 2nd of June. Now, if we look at the paragraph which begins, the other point is, I am not going to read you that paragraph, but I'm going to try and pull out 4 particular points from that page. He says, an action cannot be brought until the cause of action is complete, and in all cases of contract, the person who has to pay has the whole of the day upon which to pay, whole of the day upon which payment is due and which to pay. Therefore, until the expiration of that day, an action cannot be brought, because until then, there is no complete cause of action. So his reasoning starts by saying that the expiration of that day there is a complete cause of action. So that's his starting point. And that's my first point that I derive from this page. And I say there are 4 points, this is the first. The second point I derive from the page is this. The result is that an action cannot be brought until the next day, but it can be brought on that day because the cause of action is complete at the commencement of that day. So now he's slightly crossed over, flick the light switch, or over the fulcrum, or however you want to phrase it, to say, well, it's now complete at the commencement of the day, the following day. We go down further down the page, and there's a sentence which starts, now the day after that, on which the debtor's time for paying expires, is, in my opinion, the date on which the cause of action arises. And on that day, an action can be brought. And on that day is the first of all the days in the 6 years. So again, he's saying it's the day after. And then finally, there is the fourth point, and I'm picking up on something my Lord Burrows asked Mr. Cousins this morning to try and, as it were, deal with it at this moment. He says at the bottom of the page, I do not think that the day on which the cause of action arises is excluded. It is the previous day which is excluded, i.e. the day at the expiration of which the cause of action becomes complete. Now that final sentence I just cited to you, 2 points arise from it. Firstly, he's rather gone back to where he started by saying the cause of action is complete at the expiration of the day. I appreciate in the middle of that paragraph it rather goes in the other direction, but he comes back there. And the second thing my Lord Burrows asked Mr. Cousins was, made a next question. Was he wrong, effectively, in what he was saying, or was he reasoning that it was, in the case of a midnight deadline, that it was the right outcome to exclude that day? And obviously the answer is, I don't know, because it doesn't say in the judgment with any great specificity. But what we do know is that he had been referred to the case of Leicester, which excluded the day. He'd been referred to the case of Goldsmiths, which excluded the day, and he'd been referred to the case of Russell, which included the day in the context of a patents case. So he didn't, I quite accept he didn't have all of the cases which you have before you, but he certainly had some of them, and he had two of what Mr. Cousins has this morning selected as being two of the most important ones, that is Leicester and Goldsmiths, both of which excluded the day when the court excluded the day when the thing happened, as it were. So those 4 points I derive from that page. If I can ask you to turn to the other two reports, Gelmini decision, you'll find these. The first one is at page 411 of your bundle. And we can go straight to the end of that judgment on page 413. And this is taken from the Law Times. And again, in the present case, the time for the payment of this promissory note expired at the end of the 22nd of September. And after that time, the cause of action was complete, and an action could have been brought on the note the first time on the 23rd of September. He goes on, I do not think that the rule which has been referred to, that the day on which the cause of action arises is to be excluded from the computation, applies to exclude the first day on which the action can be brought. It is the previous day which is excluded, the day on which payment must be made, and on the expiration of which the cause of action becomes complete. Now, this is another report of an extempore judgment. I accept that immediately, but when read in that way, what he is saying is that the cause of action became complete at the expiration of the 22nd of September, and a claim could be brought at any time on the 23rd. I don't take issue with any of that at all. And that is the basis on which the case was reported in that report. There is another report, the Times Law report, and again you'll find that starts at page 414, but the passage I rely upon is at page 415, and it's the right-hand column. Again, one starts to see that there is a continuity in the reporting, and whatever it was that Mr. Justice Channell actually said came at this moment in time, and everybody thought it to be important. The sentences I rely upon are in the penultimate paragraph at the end of, right-hand column, towards a little way down. He, that's Mr. Justice Channell, did not think that the rule which excluded the day on which the cause of action arose excluded the day which was the first day on which the action could be brought. It was the previous day which was excluded, the day on which the cause of action became complete. Now, you will make what you will of those various case reports. It's plainly a shame that Mr. Justice Channell didn't reserve his judgment, do a detailed judgment, and we know exactly what he was saying. But those are the case reports that we have. And I also accept that this is an extemporary judgment by a first instance judge, and it's unfair perhaps to give it a close textual analysis akin to a contract or a statute. But what there is at least is, what it at least does show is that he considered himself to be dealing with an omission, again, to use the phrase I've adopted, at the fulcrum of the days, between 2 days. And he refers repeatedly, but I quite accept not exclusively, to the cause of action accruing at the expiration of the day for payment. So despite perhaps some what we've termed in our written case labelling difficulties, he reaches what we say is the right conclusion that the claimant had the whole of the 23rd of September on which to bring a claim, and consequently the whole of that day should be included for limitation purposes. My lords, that is what I wanted to say on those 3 case reports. On the clock on the screen I'm looking at, there is a minute to go to 1 o'clock. If that's a convenient moment. My Lord the Burrows.
Just something I would appreciate some thought being given to. It goes actually back to my Lady Arden's point about the rationale for these rules. And I wonder whether you're intending to address at all a possible argument that might go along these lines, that if in doubt, when one's dealing with limitation periods, one should err on the side of the claimant and not on the side of the defendant, because the rationale for limitation periods assume that a claimant has a valid cause of action, and that what one is doing is seeking reasons to knock out what is assumed to be a valid cause of action. Now, those reasons may be fairness to defendants, evidence, and so on. But I wonder if at some stage you could think about how you might address that argument that might say here, this might be a difficult decision. In the event of doubt, we should err on the side of the claimant.
My Lord, I can't say that was going to be a plank of my submissions, but you can be rest assured that by 2 o'clock it will be.
Thank you.
Well, we don't need to hear your submissions on that at this punctum temporis, Ms. Dixon. We will adjourn now and resume at 2 o'clock.
Okay.